A frequent topic of conversation in internet governance fora, and in particularly in ICANN now because of the GDPR, or because of the enforcement of GDPR. But we're faced with the same problem, which is what the discussion of privacy in the context of ICANN is about the privacy of people that register domain names, which is a very small number of people in the whole of internet users. And so the question is, how do we balance the rights between the two, right? Because you might make the argument of a slippery slope. If we're not there to protect the rights of the minority now, then our rights will be next, right? It's the, you know, I looked around and there was no one left to save me, right? The old saying. But at the same time, you end up with a balance of rights. We've all seen studies that show that anonymity emboldens people in terms of online bullying and things like that. There's the same article in the United Nations Declaration of Human Rights that mentions privacy also mentions the right to protect your reputation. The same article, right? So how do I protect myself from slander and libel, et cetera, if I'm unable to identify the people that are engaged in these activities? How do I balance these rights? Now, sometimes it becomes a matter of life and death, right? I mean, some of the arguments that are made is that if someone's address information is made public, then that might allow an unfriendly government, for example, to go after that registrant that's got a political website or something like that and bring about some kind of revenge on them. But at the same time, right, you have the situation where you're trying to prevent lives from being lost because of ransomware, which is becoming an epidemic here in Canada. Hospitals are getting attacked with ransomware all the time, right? And that ends up canceling surgeries, x-rays and other types of procedures that would otherwise be happening, and lives can be lost just as easily, if not maybe more easily, because I don't have the information to bring down these people and to get my data back from the people that have encrypted it. So how do we balance these rights is the conversation I wanted to try to get started. And so I thought I would just start down at the end here, and I didn't give anybody any warning about this, so everybody's just winging it. So I just want this to be an open conversation, and then when we've talked a little bit, I hope you all will join in the conversation as well. You work a lot on a number of these different human rights and promoting them. You said largely in a technological environment, like how to promote standards that then facilitate the use of these rights. Do you confront these issues of balancing rights against each other? Like, does one right sometimes conflict with another, and how does that get dealt with in your arena?
It's a question that comes up quite often, particularly from people that don't work within the human rights framework as often, right? But they're rights that are in conflict, and of course the idea is that when we talk about privacy, for example, you brought up a tension between privacy and freedom of expression. I think when people who work within the human rights framework, I think they push back on that. The idea that there's this this dichotomous tension a little bit, because when we look at the human rights framework, we tend to look at it as a comprehensive framework, right? It's not one right against another. It's looking at the framework as a whole and understanding that these are all rights that individuals possess. So it's more of it's always a dynamic assessment. It's always difficult to understand. And I think the fact that that's very complicated speaks to why it's difficult to have that conversation in a setting where that expertise isn't present, where we're not talking in the context of courts of law, where there are due process mechanisms in place. And so I recognize that tension is something that comes up quite often, but when we don't have the tools to talk about that in a legal context so easily, we can fall into a trap where we might become a little too reductive in our framing, where it's privacy against freedom of expression, or is that?
Oh, sure. I didn't mean to be reductive, except to be provocative. But
not at all. Not at all, but I naturally turned to Deborah just because I know that she works on these issues as well.
So same question?
Yeah.
Well, I think I'd almost problematize the trade-off that's implicit in the question, because I think when we start saying, okay, well, it's privacy versus security, or freedom of expression versus freedom from harassment, you're almost working from a point of weakness. And so I'm often in spaces where we're talking to governments, and this is the argument they always use because they want to surveil for security. They want to cut back on freedom of expression in order to maintain their control in different societies. So I think we need to do, as Mayor said, look at the human rights framework as a whole, that they're mutually enforcing. No human right is absolute. They all come with restrictions. Those restrictions must be outlined by law. They must be necessary and proportionate to legitimate aim. And so I don't think we're naive to say that all rights can be enjoyed in their absolute, but that they're reinforcing. And so freedom of expression isn't absolute. It's not your freedom to incite violence against someone else. Privacy isn't absolute in the sense that you can't use anonymity to, again, incite violence or to attack someone online. But I think it's not so cut and dry. And so, for example, the question of anonymity, sure, anonymity empowers people to bully people online, and that's actually been questioned in some literature. But it also allows people to fight back against bullying online. We work a lot on gender-based violence online, for example, and anonymity is one of the few ways people can come back online and reclaim those spaces. And so, and just to go to the registered question, APC ourselves, we had a staff member whose personal address was in the Whois database because that's who the website was registered to, and she got death threats to her house. So I think it's really important to look at not like the registrants against everyone else, but anyone can be a registrant, no? And anyone, it's not a binary in that. It's end users versus people working in this space, because I think if you don't protect their rights, there's a chilling effect more broadly on society. And as you mentioned, people in certain societies might be under attack from their government. There might be a chilling effect that people won't be able to go online or to use the website, create websites and engage to advance their rights or do whatever they want to do. So I think it's a little dangerous to start looking in false binaries or dichotomies and seeing that this is more complex than that. And as Mayor said, we need to have the right voices in the room to be discussing these issues.
Like a lawyer.
Like a lawyer.
I'm not speaking as a lawyer, but in any case, I wouldn't say that I think it's false to think of these as binaries, or they are binary, or they're false when you think about them as binaries, because it is more of a subtle balancing, and I think that he was even, or a delicate balancing was in the title of this program. So, but I'd like to actually take a step back. I recently had a chance in preparing for a presentation to kind of look over the history of privacy. And really until relatively recently, privacy was not about information or data privacy. It was really much more about physical privacy, the right to be safe in your home, the right to, particularly often stated as the right to not have the government in your bedroom, or to have government intercede in your life, kind of the right to be let alone. And it's really only relatively recently that information privacy or data protection has kind of that level of, or how information relates to privacy has kind of overwhelmed the discussion of kind of the actual being private. So I think that's just an interesting perspective. In a sense, the first privacy law in the Constitution is the law against, or the amendment, I think it's the Third Amendment, which prevents the quartering of soldiers in your home, that which the British like to do to the Americans before we were Americans. They just move a whole bunch of British soldiers in and say, okay, they're now living in your house, oh, and by the way, you're doing all their cooking and cleaning too. That was an invasion of privacy in a very fundamental way. Thankfully we've gone beyond that, at least in some places, but not everywhere, I'm sure. So I think that the balance, in a sense, is not so much between privacy and freedom of expression, but it's between various understandings of privacy and things that get grouped under privacy. And while you shouldn't be able to use privacy as a way to achieve anonymity for the purposes of bullying or spamming or theft, it in fact is used that way. And somewhat like a gun, it's a weapon that can be both positive and negative depending upon who uses it. Unlike a gun, it has much less ability to immediately kill people, but it is still something that needs to be dealt with kind of responsibly. But it's very hard to distinguish as to whose privacy you're dealing with and whether what you're dealing with is actually even privacy. The right to proceed anonymously, the right to be secretive, is not necessarily the same thing as the right to privacy or the right to be let alone or the right to be able to express yourself freely without harassment or fear. Sometimes you need privacy to get to those other things, which in a way makes them more fundamentally part of privacy. And I think within the ICANN space, while different people can be different things at different times, you can be a registrant, you can be a trademark owner, you can be an end user. Within at large, at least, I think it's incumbent to wear our end user hat at all times and think about how it affects end users. There are others who will speak for registrants as such. At the same time, internet governance doesn't work if you only think about your own parochial interests, even if they are the parochial interests of 3.5 billion people. It really works when you take other people's interests and considerations into account and try not just to